Right. Good morning, ladies and gentlemen. Welcome to another episode of PLA with myself, Nick, and Bruno. We've got two questions in one for each of the gentlemen. The first question is going to go out to Bruno, and it reads as follows. Bruno is, I believe, it's from an estate agent. There's a lease expired, and before it expired, the agent sent an email to the agency to let them know that I will be cancelling the mandate, right? The tenants then chose to stay in the property. The property practitioner, however, does not have an FFC, but the agency has the FFC certificate. Their attorney sent a letter of demand for commission as the tenants are still as the tenants are still staying on the property and also refuse to accept the cancellation of the mandate. They also refuse to pay the deposit to the tenants. So what we have here then after that, we've got two follow-up questions, which are please advise if number one, I owe the agency commission as the property practitioner never had an FFC certificate. And then secondly, the tenants, can they demand for their deposit from the agency and whether then they must sign a new agreement as per that letter of demand with the agency for the tenants to stay in the property.
Sure, it's it's quite a loaded question.
Yeah.
Let's break it down into smaller pieces. Maybe it'll be a bit easier to answer. So the lease is expired. So there is no lease in place at the moment. There's a mandate between the landlord and the estate agency. So maybe let's deal with that first. So it's a mandate. What does that mean? The landlord instructed the estate agency to perform a certain function. What that function is basically going to be in the mandate. But before we get to that point, the FFC question. Now, does the fact that the person in the estate agency, the actual person themselves that was dealing with this, not have an FFC certificate, is that a problem? Provided that the agency does have an FFC certificate, right? Interestingly enough, and Nick, maybe you can jump in here because I'm struggling to remember the specific section, but in terms of the old legislation, the Estate Agency Affairs Act, every person dealing with any specific transaction had to have a Fidelity Fund Certificate provided by the Estate Agency Affairs Board. We were recently looking at a specific case where it was lease management, and there's a particular exception that says that if a company actually has a FSC certificate, the employees, I'm actually lying. The person in the company, provided that there's one practitioner that has a FSC certificate, the company itself need not have a FFC certificate. But in these particular circumstances, the way that I understand it is the actual person themselves has to have a certificate. The company might not have to, but in this case, the company has and the person doesn't. So Nick, if I'm not mistaken, that obviously doesn't form part of the exception. So as far as I'm concerned, this obviously is abnormal. This is something that is reported.
Yeah, so I think you've got to with when it comes to agents, you've got to be very careful about the legislation because it's not a requirement that everyone that works within a particular state agency has an FFC. That's not the requirement. But you can't perform the functions of an estate agent without having an FFC issued to you. Okay, so I think Bruno, with regards to this question, you could be right. I think it could be the other way as well. We don't have enough detail in the question to know exactly what the person or functioning in that chair was actually doing. I'm inclined to agree with you in the sense that it does seem that this person would fall into the category of someone who has to have an FFC and profess to be the estate agent in the circumstances. But you'd really have to eat into the matter to see, is that the case, or is this someone like, the law doesn't expect someone like an assistant secretary, someone like that, to necessarily have an FFC in the circumstances. But the provision comes then, they cannot perform any function that may be interpreted as one that an estate agent does. They're basically, they send emails on behalf of other people where the other people are giving advice.
Which is an interesting notion to debate, because bear in mind that obviously, coming to the second portion of the question, when one looks at the difference between procurement as a mandate and lease administration as a mandate, the actual account manager, as an example, being, the person behind the computer screen, punching in the numbers, capturing an actual payment, and clicking the button that the invoice goes out with. Technically, that person, in my mind, is purely of an assistive nature, ancillary to the function of an estate agent. Yes, if there's a complaint and a question of a deposit, there would be the agent that has to come in and deal with it. But the person pressing that send button is the account administrator, and very often, and I deal with this on my properties as well, the person I land up communicating with the most sometimes is the account administrators giving me updates on the figures. The estate agent only comes in when something breaks and they're trying to tell you that it needs to be fixed. So yeah, to that point, I think the function would have to be clarified as to, is this the same person that did everything, or are you dealing with different people in the agency and you're just now kind of picking on one? Okay, cool. So that's the first part of the question. Second part of the question is understanding the extent of the mandate. So is it a procurement mandate? That means, was their job only to acquire the tenant? Was it a management mandate, which means, was their job to manage the lease on an ongoing basis? So every month, if there's a complaint, they have to communicate with you. If there's an inspection that needs to be done, they need to do the inspection, they need to account to you, etc., make payments to you, basically act on your behalf as your agent, basically acting as a landlord on your behalf. There's this little bit of a gray area sometimes where people don't quite understand these are two different functions. So estate agents come in with one big function, they offer you this big product and go, we'll do this and we'll charge you 10% per month. And it includes both the procurement and the management mandate. Some mandates are clear enough to express that if for some reason during the tenancy, at any point, even during renewals, if the management mandate is cancelled, there's going to be a reversion back to a fee being charged for procurement. So just be careful. So again, the wording of the mandate is going to be very, very important here, because the mandate may very well say, if you cancel and the tenant's still there, sorry, but then you owe us a procurement mandate because we did get the tenant and we are only willing to forego this because you are keeping us on to manage. As soon as you fire us from management, then give us our money for having found the tenant to begin with, right? So that's also something to bear in mind. Then property practice. Okay, so the FFC, the tenant, insofar as the tenant staying on the property is concerned, and the deposit. If the mandate is cancelled, remember the deposit is being held on behalf of the tenant. The deposit can't be accessed as easily as that. So the agents shouldn't be able to retain the deposit if the tenant did want it back. So at any point, it is payable to the tenant. If a new lease agreement signed and the tenant now sits with you and you've paid your commission, that deposit has to be released. I don't find any justification or grounds for the estate agency to hang on to that deposit, because it's not like they can utilize it in any way, because it's not the landlord's money. The landlord owes commission. That deposit doesn't belong to the landlord. So as far as I'm concerned, the estate agents shouldn't be able to hang on to that deposit at all. And must a new agreement be signed with the agency? I'm not sure about that second part of the question, but if the tenant wants to stay on, there's no reason why you can't use the existing agreement and just rely on an extension or a renewal on that agreement. That agreement isn't exclusive to the estate agency. It's an agreement between the landlord and the tenant. So you can just rely on that and have the tenant stay on based on that agreement. And like I said, the deposit is held on the landlord's behalf, but it belongs to the tenant. So as soon as the lease is completely expired and the tenant is moving out, that deposit would have to be released, subject obviously to any damages to the property.
I think the only thing I want to add there is, obviously, like you touched on at the end, the deposit which is held in respect of a lease agreement belongs to the tenant. It is simply held as a security by the landlord in the circumstance. So in this question, they said, can the tenants demand the repayment of the deposit? And I think there might be a problem there. I think the ultimate responsibility actually sits on the landlord, because depending on whether this lease agreement is actually coming to an end or is going to continue in some sort of fashion, the obligation is on the landlord to secure that deposit and hold it in an interest-bearing account in terms of the Rental Housing Act. So, and I think there might be a problem if the tenants try and demand payment to them.
Sure.
Because that obligation to hold sits with the landlord. So yes, there's an ability, I agree with you, to get the deposit back, but it might not sit in the tenant's hands. It might actually sit in the landlord's hands because they're the ones who are ultimately caring for this deposit at that time.
Sure.
Absolutely. So thank you very much to our agent. That is the answer. And if you do have more specifics, then you can just comment on the bottom and we can provide a written response, maybe in the replies.